State of Tennessee v. James Robert Howell.
Good morning. May it please the court, Gregory Isaacs here for the appellant Robert Howell. Mr. Howell was charged in an 8-count.
Did you want rebuttal?
After you.
It's okay.
I would like to reserve. I did that last time I was here. May I please reserve 5 minutes for rebuttal?
Yes. Thank you.
Thank you. Mr. Howell was indicted in an 8-count indictment in the Knox County Criminal Court. 1 count of rape. The remaining counts were sexual battery. The facts and material facts supporting the indictment are as follows. In August of 2001, August 5th, 2 young girls were having a sleepover. SC resided at the home of Mr. Howell and Laura Howell. Laura Howell was SC's great aunt. She had adopted SC when she was extremely young, 4 or 5, because she had been sexually abused by her biological father. She and a friend, JR, were having a sleepover. On the night in question, the girls thought that it would be funny to prank Mr. Howell, and they told him that there was a boy in the house that had come over and they had snuck in. Mr. Howell, according to the record, had been drinking somewhat. He became irate about the prank, went to the girl's bedroom, and then there are differing accounts as to what transpired next. SC stated that he laid in bed, pulled his pants down, rubbed his penis on her buttocks, and forced her to touch it with his hand and attempted to place his hand down her pants. JR testified that he touched her briefly, a few seconds, outside her clothing on her buttocks, and touched her bare thigh for maybe 4 seconds. The girls leave the bedroom, go outside to the living room area, and JR allegedly made a statement. The statement was that Mr. Howell had allegedly touched her down there. The girls go back in the bedroom. They place a dresser in front of the door. SC subsequently texts her great aunt Laura in the early morning hours of August 5th and stated that he had tried to put his hand down her pants but makes no mention of him being unclothed, forcing her to touch his genitalia, etc. We have 5 material issues regarding those facts. Significantly on the night in question, Mr. Howell vehemently denied any wrongdoing or any appropriate conduct. Laura Howell, the wife of Mr. Howell at the time, and the great aunt of SC did not call law enforcement. She informed the, I think the record would reflect, grandfather or papaw of JR, who later called the police after he spoke with his granddaughter when they returned home. The first issue that we think is very significant based on the credibility of the testimony of the young girls, JC and AR, is the court allowed a hearsay statement regarding the touching. There was an objection made contemporaneously at trial. The judge indicated that it was hearsay. State's response was it was an excited utterance. Clearly under Tennessee law, under the Banks test, for the statement to have been an excited utterance, and it was made in the context of when JR left the bedroom. It has to be a startling event or condition. The statement has to relate to that startling event or condition, and the declarant has to be under the stress of that condition at the time the startling event occurred and the statement was made.
Didn't SC testify that that JR was shaking and clearly scared when she made that statement?
She testified that she was shaking and that she appeared or looked scared and was mumbling.
Okay.
There was no testimony that she was crying, that she was irate, that she was doing.
Does she have to be crying? Does she have to be irate? I mean,
Well,
if she's
you know-
shaking and having trouble getting the words out and appears to the person who hears it to be scared, is that not enough?
Well, when you place it in the context of JR's subsequent testimony at trial, which she denied the events took place, that Mr. Howell tried to touch her down there when she testified under oath, and she was going to testify at trial. So at that point, I think the state failed. I think there needed to be more under the Banks test, because shaking and mumbling, I don't know, rises to the level of an excited utterance, which was later disavowed by JR when she testified at trial.
Well, but I mean, the disavowing later, I don't know how that weighs into the excited utterance at the time. I mean, you have victims and witnesses in any kind of case who make a statement at one point in time, and then you get to trial, and for whatever reason, they recant. That doesn't mean that the initial statement is not admissible. And I mean, in here you have a child who runs out of the room when this happens. They both jump out of the bed and run out of the room. They get outside and away from the individual, and she's shaking and scared and makes a statement. I just don't see how that doesn't qualify as an excited utterance.
Well, respectfully, and if you look at JR's testimony throughout the trial, it was consistently inconsistent, because not only did she disavow the excited utterance that SC said she made, she also denied that they had planned this prank on Mr. Howell, telling him that they had snuck a boy in the room for some time. But when you look at it in that context, we would assert that that was not a sufficient foundation.
Okay, well, I'm gonna ask this one more time a little differently. So if I give a statement, which by all accounts is an admissible statement, or make a statement,
Yes,
by all
sir.
accounts it is admissible, and then I get to trial and I say, nope, didn't happen that way, whatever, disavow it completely, does that make the first statement not admissible? It just goes to credibility. It doesn't go to admissibility.
It does not, and under the 8032 exception for excited utterance, I don't think mumbling and shaking constituted
So
enough.
that's what I'm trying to say. Like, you keep pointing out that she disavowed this at trial. That doesn't make this more or less admissible. It makes it more or less credible.
Correct.
Okay.
That's why this was a material error by the trial court. The second issue we'd like to address is that the court omitted evidence or argument of grooming. Significantly, the original counsel was an appointed lawyer who filed a 404B notice very promptly after they were appointed. However, the state failed to disclose that they were operating under the theory that Mr. Howell had groomed SC, and it's our position that before that testimony, that evidence should have come in oral or in closing argument.
Yeah, but so that's my question. There wasn't actually any evidence that came in at trial to that effect. Wasn't it just all in closing argument?
Yeah, it was argument pointing to the evidence that constituted grooming. So it was presented to the jury in a roundabout way, but it talked about him wanting to push the envelope, having done this for a period of years. And the only evidence that really came in, aside from the conduct on August 5th, 2021, was a number of text messages and him occasionally sleeping in the same bed.
But there wasn't any kind of objection at trial or even about the closing arguments, was there?
No, we are asking the court to view this under the plain
Plain
error review standard. And under State versus Potabom, I think that's a very insightful case where you have someone that had provided marijuana to a minor, had showed the minor pornography, and it talks about how the 404B evidence has to be used as something that leads up to the crime. And in this case, there was no ability. Again, counsel should have objected, but the record is clear on what transpired. That was a clear, unequivocal rule of law that there should have been a 404B hearing, and there was a motion filed previously on this issue, a 404B issue. There was not a tactical waiver. It is a substantial.
Why, I'm confused. If there's no testimony or proof at trial as to, quote, the grooming, and it's a statement and it's rather a statement in closing argument, why is there a 404 hearing? Isn't it just a prosecutorial misconduct argument straight up for improper argument?
Yes, it could be, but our position is if the testimony they elicited was going to be later.
I think that was Judge Ayer's question. Maybe I misunderstood it, but there wasn't really any testimony about, quote, grooming that was presented at trial. This was all a statement. This was all a statement made during closing argument.
Well, what the state did was take evidence that had been presented at trial and then try to label it and promote it to the jury as grooming.
Are you saying that evidence was inadmissible?
I'm saying that there should have been a hearing if it was being offered for grooming under Potabom and 404B. There should have been a jury out hearing. There should have been a determination by Judge Sword. If that conduct constituted hearing, there should have been a finding by clear and convincing evidence, and then a balancing under 401 and 403 on whether if its potential prejudice outweighed its probative value.
And what is the specific evidence that you're complaining about?
Evidence that he slept in bed with her, that he would send her text messages frequently, primary caregiver. Those very benign things at closing argument were lumped into constitute
Aren't those
grooming.
the basic elements that the state had to prove?
But to talk about grooming, and he had for years tried to, quote, push the envelope and had planned this, they basically inappropriately characterized all the evidence that came in.
Well, that goes, then that you just, I think you just answered our question with your statement, and that is, that all goes to the inappropriate, it all goes to the inappropriate, according to your argument, the inappropriateness of his argument, not the inadmissibility of the evidence. So it seems to me, and just hearing you talk just now, and then responding to Judge Ayer's question, that you're really making a prosecutorial misconduct argument and not necessarily a 404 argument, because there's something really wrong with the proof that came in. What's wrong is the statement, is how he used that proof.
The state's theory is, I believe, what my colleagues are saying in argument. That's how the state used it, not the evidence itself.
Yeah, yes, that's how the prosecution used it in closing argument, but it is our position that if they were offering it as 404B evidence of grooming, then there should have been a Potabom hearing and a 404B hearing. For example, if there's evidence that someone slept in the same bed or sent text messages, it doesn't make a fact of consequence more or less probable. Well, if it's being offered for grooming, it would be a different standard.
Let me ask you this then, okay? If that's the case, let's say we agree with you, what happened at trial to let anyone know that they were using this for a grooming argument, and therefore there should have been a 404 hearing? Because the way I kind of understand it is they just took bits and pieces of proof, and then they didn't make an argument in opening, so you didn't know it then. They have these bits and pieces of proof. How is anybody supposed to know, whether it's trial counsel or the trial court, hey, this testimony may lead to a grooming question later, so I need to have a 404B hearing?
Well, and it put the defense counsel in a very untenable position, because they didn't know to object that they were going to take this mosaic or this kind of patchwork quilt, and they were building an argument
right.
for grooming.
So if they didn't know it, how's the trial judge supposed to know he needs to conduct a 404B hearing?
Yeah, how is that error on the trial court's part for failing to have a hearing?
It may be a post-conviction issue later, but how is it an error on the trial court's part?
Well, when they moved for the motion for judgment acquittal, which in this case the proof was so inconsistent, Judge Sword granted a motion for judgment acquittal on the rape case and counts 3 and 4 of the sex bat cases. I think he could have done the right thing based on the fact that they were packaging this evidence that came in under one standard or threshold of relevance and was now being used under a separate theory, and they knew all along that was the issue.
You can finish your thought.
But that's and again, there's a number of these issues that touch on ineffective counsel, and it's whatever. But the other issue, and I'm about out of time, is allowing testimony that SC had been previously sexually molested. We think that was highly prejudicial, inappropriate, and we have it's set forth in our sentencing memorandum argument section some factors that we felt that the main thing, if I could just continue, well, I have 30 seconds. Under the sentencing prong, Judge Sword, who always was very methodical and excellent in applying all the factors, and now is one of your old colleagues, started from the top and applied enhancing and mitigating factors in working the sentence down, a Class C felony. So he found that there was a mitigating factor, that there was no serious bodily injury, et cetera. He also made some oblique comments in the record that Mr. Howell had been a good provider. But he also found an enhancing factor that there was prior criminal conduct in history, because SC completely changed her story and then said that she had been groomed, she had been touched in the buttocks, he had slept in the bed, had touched her inappropriately in her breast for years. Judge Sword admitted, he goes, that's totally antithetical of what I heard at trial. But nevertheless, he said he started from the top of the range, contrary to Carter, and worked his way down to impose a 4-year sentence on the counts that merged, counts 2, 6, 7, and 8 merged, not 8, the others merged. And he should have started from the bottom and applied post-Blakely the enhancing factors to get from the bottom of the range. So, and we also strongly take issue with the fact that he denied Mr. Howell probation. I think this was an excellent case. You know, Judge Sword talked about his prior criminal record. He said it was minimal. Mr. Howell only had a misdemeanor conviction in 1991. He was gainfully employed. And the other thing that Judge Sword did in denying probation, because Mr. Howell, in his allocution, maintained his innocence, said that he was not amenable for rehabilitation because Dr. Adler testified in the psychosexual that he could not render an opinion that would be helpful because Mr. Howell would not admit that he did anything wrong. So anyhow, we think those are material issues in sentencing, and I'll reserve the rest of my time in rebuttal.
Thank you, counsel. General, what say you?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments for a variety of reasons. First, the trial court properly admitted an excited utterance. Second, the defendant has not met his burden of establishing plain error with regards to either this improper closing argument or the admission of some sort of evidence, because the trial court or the defendant also cannot meet his burden of establishing plain error with regards to a line of questioning on SC's prior sexual abuse. And I think the only other issue that was raised today is sentencing, and this court should affirm because the trial court properly exercised its discretion. My friend on the other side did not bring up sufficiency. Unless this court has questions on that, the state will rely on its brief. With that, Turning to the first issue, I was going to give a factual background, but I think we all agree exactly what happened. SC testified that the defendant touched her inappropriately. JR testified that the defendant touched her inappropriately. The jury convicted. So that's sufficient factual background, I think. Moving to this excited utterance first. The trial court properly admitted this because it was an excited utterance. And Judge Dyer, I think your questions hit the nail on the head. Ultimately, this was a 14-year-old girl who had just been groped by a 50-something-year-old man who goes out to her friend in the living room immediately after the assault happened. She is, as SC testified, she looked scared and she was shaking like so much. The trial court could reasonably find that the instance of groping had put JR in such a state that her utterance that the defendant touched her down there was excited. It's pretty straightforward. But
Do we
even
take into account at all that she denied it later?
No. When you are looking at whether an utterance is excited, you look at the state of the person who's saying that, their state of mind at the time. It doesn't matter if they disown it later. It doesn't matter if the state knows they're going to testify later. The question is, whether it's an excited utterance, what was their state of mind at the time? And here, state submits that it was very clearly an excited utterance. But even on the off chance that this court disagrees, any error is certainly harmless. The defendant focuses on how JR disavowed this. That I would characterize it a little differently. JR clarified what she meant by that, and said that the defendant had in fact touched her on her buttocks and had touched her on the bare skin of her thigh. She testified at trial, so to the extent that any error admitting this out-of-court statement was a problem, JR testified and clarified exactly what the defendant did to her. Any error was harmless. Moving to the next issue that my friend on the other side addressed, I think it is only properly before this court as an improper closing argument. My understanding of the motion for new trial was that they took issue with the state's comment of the state's use of the word grooming in closing argument, and that seems to be the substance of their argument in their brief as well. But very briefly, I'll touch on this evidentiary claim 404B issue. I believe the evidence in question that has been discussed is the fact that the defendant has slept in SC's bed before, that he sent her certain text messages, and that he was her primary caregiver at certain times. None of those are prior bad acts, so they do not fall, in and of themselves, they do not fall under Rule 404B. Your Honors had questions about how could this have been known to the trial court or to the defense counsel or even to the state. It couldn't have, because they are not prior bad acts. So to the extent that the defendant is raising an evidentiary claim as to that proof, not only is it waived and inadequately briefed, we would submit, but also just loses on the merits because 404B does not apply.
General, there was a discussion of 404B pre-trial, was there not?
Yes.
What does the record show? Was the substance of the 404B allegations, was it discussed on the record in this hearing?
So the record will be a little bit more accurate, but my recollection is that this was sort of an omnibus 404B motion by the defense, which was a different attorney at the time, who just said, let me know if you plan on using any prior bad acts against the defendant. And through communications, the state had said, we don't intend to sort of use any propensity evidence or any prior bad acts. That's my understanding of sort of how things played out. Again, the record will be more accurate if I'm mistaken on that. But ultimately, there was never any real question of sort of propensity of prior bad acts. But turning to what I think is proper, the improper closing argument claim, this issue is waived. And I think, I noted that the defendant's brief doesn't address any of the plain error factors. I think those were at least touched on today, but the defendant can't meet his burden of establishing all 5 plain error requirements. First of all, there was no breach of a clear and unequivocal rule of law. These were reasonable inferences from the proof. Again, the defendant points to proof that the defendant had been sleeping in SC's bed multiple times prior to this particular instance, that he sent certain text messages that gave a certain inference, that he was her caregiver, that he was in a position of authority, and the state was allowed to use that proof to make a rational inference that what the defendant did here on this particular night was try to push the boundaries even further, was to take this one step further. Instead of just sleeping in the bed, start to sexually assault SC. That's a rational inference that the state's allowed to do. So there was no breach of a clear and unequivocal rule of law. The defendant also cannot show that waiver was not tactical. In fact, this court repeatedly comments that decisions on whether or not to object are often strategic. And finally, consideration is not necessary to do substantial justice. Again, the proof overwhelmingly establishes guilt with direct testimony from both victims. So the defendant is not entitled to plain error relief on this improper closing argument claim. The defendant mentioned it, so I'll briefly talk about this line of questioning regarding prior sexual abuse. Again, this is waived. The defendant did not contemporaneously object. He cannot establish all 5 plain error requirements. There was no breach of a clear and unequivocal rule of law.
How is her prior abuse relevant to what the defendant did here, though?
It's to establish his position of authority. So what we need to know is the defendant was in a position of authority over SC because SC had been adopted by her aunt, who was married to the defendant. So SC's aunt legally adopted her after this abuse. She became her legal custodian. Shortly thereafter, I think 2 years later, she married the defendant, the aunt did, and the defendant became placed in a position of authority over SC. So that's what it had to do. And when this court looks at the record and sees the line of questioning, it was very quick. It was asking the aunt.
That's what I was going to ask. Wasn't it just something that seemed like it kind of came out about how did you come to get custody of SC, and it just came out, well, because of this, I gained custody of her.
Exactly. So it was relevant to establish how the aunt ultimately got custody of SC and how the defendant was in a position of authority over her, which is an element of the offense.
I mean, I think we could question whether it was actually relevant or necessary, but I think the bottom line is there was no objection to it on that basis.
Exactly. So when we're looking at this under the lens of plain error, there's no clear and unequivocal rule of law that this breached. Further, this is merely an evidentiary issue, and this court has repeatedly commented that evidentiary issues do not implicate substantial rights, which are constitutional in nature. Again, this was something that could have been objected to, and the defendant hasn't established that this was not a tactical decision. And again, the evidence overwhelmingly established guilt, so the defendant cannot meet his burden on appeal of establishing all 5 plain error requirements. If there are no further questions on that, I'll move briefly to sentencing. The defendant takes issue with several aspects of his sentence. The trial court's findings were incredibly thorough. When this court looks at the transcript, it will see exactly what the court found. First, with regard to the denial of alternative sentencing, the trial court made several findings, and in fact found several in favor of the defendant. It explicitly held that the criminal history didn't weigh in favor of confinement, and that lesser measures being applied, that it wasn't going to consider that in determining confinement. But what it did focus on was the doctor's report that said the defendant had a very poor chance for rehabilitation. And I want to be very clear about that distinction, because the defendant complains that the court sort of punishes him for maintaining his innocence, and that's not what the court did. The court focused and said on the fact that because the defendant maintained his innocence, he had a poor chance at rehabilitation. So it wasn't the act of maintaining innocence, it was the lack of ability to be rehabilitated that the court relied on. And then on top of that, even if this court finds an issue with that, the court pointed out the deterrent effect. These were 2 young children. It commented on sort of the scope of sexual assaults in the area and said that this needed to be in confinement because it would have a deterrent effect on other conduct. Moving on, the defendant argues he should have been classified as an especially mitigated offender. The court found an enhancement factor. He's not an especially mitigated offender. I think lastly, the defendant, he takes two more issues. First, he maintains he's entitled to a bottom of the range sentence. He's taken some issue with the fact of where the trial court started out. I think that doesn't matter. There, at post-Blakely, and especially post-Buys, there is no presumptive starting range. Instead, what the court has to do is consider mitigation factors, consider enhancement factors, make all the other relevant considerations, and explain its reasons for the sentence it imposes. And that's what the trial court did here. It found the presence of an enhancement factor. It found the presence of several mitigating factors. And it said, I'm weighing these out, and I think 1 year above the minimum is an appropriate sentence. That's a reasonable determination. And then finally, the defendant complains about the consecutive nature of his sentences. There were multiple victims in this case. That is a factor that allows the court to impose consecutive sentencing. It made that finding. This court should affirm. Unless this court has other questions, again, we ask that you affirm the judgments. Thank you.
I don't know how much time you have left.
If any.
Does he have any time left? 2 minutes.
I will be brief. Since we talked about the credibility in the statements, on the sufficiency of the evidence issue, this is a case with no forensic evidence. You have primarily the testimony of SC. SC had...
The statement of the victim is enough. The case law is very clear. I don't need forensic evidence. The statement of a victim of a rape or a sexual abuse is sufficient in and of itself, is it not?
Correct. In SC's testimony that her friend, JR, had said that she had been touched down there, later was disavowed at trial. They also disavowed that they had planned this prank together that set this wheel in motion. And also, Laura Howell, the great aunt, said that SC had some significant credibility problems. But back to end on the sentencing, Judge Sword, even though that Mr. Howell had only a misdemeanor conviction dating back to 1991, characterized it as somewhat of an extensive record. And when he listened and factored in the testimony of SC about the prior acts of touching her inappropriately, he on the record noted that that was completely inconsistent. But we also think that he did hold against Mr. Howell and his allocution and the fact that he told Dr. Adler that he was innocent. And we think he should have been given probation or have been given a classified as a mitigated offender. Thank you.
Thank you. Thank you both very much.